Barbara, and thank you all for the invitation to participate in this important dialogue. I'm delighted to be here. I do think that what is important about this event is that it is a dialogue. Too often with this topic, I think advocates assume that it is obvious what the goal is and that the only real need is the will to accomplish it. I think we are actually at a time when we need to think more carefully about what the goal is and to listen more carefully to one another. Some years ago, well, actually many years ago now, the Catholic Church in the United States had a formal dialogue with women. And just before the scheduled local meetings between bishops and women started, a reporter from the New York Times went to Archbishop Rembert Weekland of Milwaukee and asked him what he thought about the situation of women in the church. And Bishop Weekland answered that he did not yet know what he thought because he had not yet listened to the women. The reporter was astonished that he didn't have his whole program worked out already. It seems to me that we could all, certainly we who are academics and lawyers, learn something from Bishop Weekland and listen before we talk. But of course I will talk now, and I hope I will listen too. So Professor Seljak has told the story of one country's experience with religious difference and various efforts legally to intervene and manage those differences. Thank you, David. I learned a lot. I have been engaged in some cross-border conversation over the years, and I know some about Canada, but I'm still learning. And so while the Ontario issues are obviously important to this time and place, virtually every country in the world is doing something like this right now. The U.S., which often proudly asserts that it knows how to do religious freedom, is once again sorting through the details of what that means, not just for new immigrants, but even for the dominant Christian communities. So while religion and law in the U.S. and Canada might superficially seem similar, we have a common legal heritage, and many of the same religious communities are present in both countries, and yet we understand religious freedom differently. We have different political histories and cultures, and we talk about religion in different ways. We in the U.S. do not talk much about multiculturalism or of creeds. These seem like unfamiliar languages to an American lawyer. We do talk a lot about freedom, but we seem increasingly unclear about what that means, particularly when it comes to religion. So first I want to say that the idea and practice of religious freedom has many histories and is understood differently in different times and places. I don't think that can be emphasized too much. There is not a singular notion or practice of religious freedom such that all we need to do is measure how close or how far any one group or any one country or any one place in the world is from that ideal. There are many ways of thinking about religious freedom, and as I say, we need to listen to each other. But legally to enforce any version of religious freedom requires a determination as to what counts as religion in a particular time and place. And it is this problem of what we mean by religion, when we talk about religious freedom. And I will use the word religion, notwithstanding, I know sort of super Canadian sensitivity to always talk about religion and non-religion, and creed and non-creed, and I respect that, but that's not how we talk about things in the U.S. You'll just have to listen to me in my backward U.S. way talk about religion without saying and non-religion every time. So I'm going to talk, as David and Barbara said, about one very specific case, because I do think sometimes it's very helpful in thinking through these problems, not to speak at a general level, but to talk about actual people in a very specific place. And this is not a terribly important case. These are ordinary Protestants, Catholics, and Jews living in the United States, but who had a problem in which their religious practices were not allowed. And just to think at a very micro level here about how these issues worked out. So some years ago, I was an expert witness in a trial in Florida. And the plaintiffs in this trial were a group of people whose relatives are buried in a city cemetery there. The cemetery regulations limited what could be placed on the graves to small flat plaques flush with the ground in a style common to newer cemeteries in the U.S. These regulations had both practical and aesthetic purposes, to make them easier to mow over, as well as to make the cemetery look tidy and garden-like. And no vertical memorials are permitted in these cemeteries. Over a period of years, however, the cemetery managers at this particular cemetery in Boca Raton, Florida, had allowed people to build homemade memorials on the graves. And over 400 Protestant, Catholic, and Jewish families had built these homemade, above-the-ground little memorials or shrines on the graves of their deceased relatives. For example, a Lebanese immigrant who called himself a born-again Christian made a 4-foot-high wooden cross covered with silk lilies to place on his wife's grave, as a witness, he said, to their faith in the resurrection. A Jewish couple from England whose son had died young in a car crash put a stone Star of David on his grave and surrounded it with a fence and plantings to prevent people from walking on it, as they had been taught that Jewish law required. And 2 Cuban sisters whose brother had committed suicide placed a large statue of the Sacred Heart of Jesus and planters with offerings of flowers on their brother's grave. They visited and prayed often for his salvation because they believed that suicide was an unforgivable sin. And there were many more, carefully assembled but modest collections of statues, flowers, vases, inscriptions, crosses, stars of David. The aesthetic reminds one of roadside memorials at the scene of car accidents or the impromptu shrines built at the scenes of disasters. All of these assemblages were in violation of the regulations, but they were tolerated, even at times encouraged, by the cemetery management, who openly admired the care and piety of the plaintiffs. But after about 15 years, beginning in the late 90s, the city decided to start enforcing the regulations and announced that everything on the graves that did not conform to the regulations would be removed. The reasons given were safety and economic, the difficulty of maintenance and working around these memorials when new graves were dug. But some people suspected that there were also class considerations, that the little homemade installations were considered tacky. After an attempt to settle the matter through the City Council, the American Civil Liberties Union brought a lawsuit on behalf of those who had placed the non-conforming memorials on the graves, arguing that the city's actions violated the then newly passed Florida Religious Freedom Act, and as well as the First Amendment to the United States Constitution. The testimony of the plaintiffs at the trial was very moving. 11 plaintiffs testified concerning their actions in the cemetery. They said that they had chosen the cemetery because they had admired the many personalized memorials already there, because it was close to their house or their place of worship, and because they liked the religious diversity of the cemetery. It was what American religion was to them. Some people were asked on cross-examination, so if you wanted to have Catholic statues on your father's cemetery, why didn't you bury him in a Catholic cemetery? And the woman said, but that's not who my father was. My father knew people of all faiths, and I wanted him to be in a cemetery like that. So there was a sense among the plaintiffs that that cemetery, in all its hodgepodgeness, represented the strength of American religious freedom. The immigrant plaintiffs talked about the lack of religious freedom in their home countries. Each told how and why they had selected the items that made the small spaces holy and reminded them of the relatives who were buried there. Mostly they referred to family tradition and religious upbringing to explain their choices. And they all talked about their frequent visits to the graves. So in addition to the plaintiffs themselves, the lawyers for the plaintiffs put on several expert witnesses. One who knew about cemetery design, one who knew about the economics of the cemetery industry, and 3 scholars of religion. This kind of litigation is really good for religion scholars. The 3 scholars of religion were there to explain on behalf of the plaintiffs why what they did was religious. Because the central issue in this trial was what counts as religion. Was what they did on these graves religion? Because it had to be religion in order to qualify for any kind of claim to an exemption from the law. The city said that what the plaintiffs had done was not real religion because their religions had not required them to build these memorials. The city seemed to imply that religion is the kind of thing that if you look in one of the books belonging to a religion, or you ask somebody in charge, you will find a lot of rules about what you're supposed to do, including very specific rules about what to do on a grave. If you were doing something that's not written down somewhere or not told to you by a religious leader, the city further implied, then what you're doing is not really religious. And they kept asking the plaintiffs, where is this written down in your holy text? What priest told you to do this? What rabbi told you to do this? The plaintiffs and the religion scholars who testified to the plaintiffs had a different view. They described religious practices that were, to some extent, improvised, within certain parameters, to be sure, but they saw religious people as creative interpreters of their received traditions, who riffed, if you like, on what they had been taught by their families, what they had learned in religious education, even what they'd seen on TV. But we, the religion experts who testified for the plaintiffs, all said that improvisation did not make what they did any less religious or any less important, or even less obligatory to the plaintiffs. For example, the expert in Jewish law, Michael Broidy, an Orthodox rabbi who teaches at Emory, testified that Jewish law is found in a number of places, in the Bible, in the writings of the rabbis, and in the customs of the people. He said that the things that the Jewish plaintiffs did to protect the grave, while not specifically mandated by Jewish legal texts, were consistent with a tradition of Jewish burial practice that could be traced back to Jacob's raising a monument to Rachel, as recorded in the book of Genesis. He focused particularly on the concern expressed in Jewish law from the beginning of rabbinic Judaism about the removal of items that are already on a grave. The Emory rabbi readily agreed with the city's lawyer that it would be okay to have a Jewish grave without a raised memorial. But he was emphatic that the writings of the sages are very clear that an existing burial site must not be disturbed or altered because of the honor due that holy place and those who are interred there. The church historian, John McGuckin, testified that what the Christian plaintiffs had done was very typical of what he called Latin piety, that is, the religious practices of Roman Christians since early times. He disagreed with the city's expert, who had written in his report that Christians were really not very interested in burial because they were focused on the next life. Professor McGuckin was an unusual choice for an expert on American religion. He teaches at Union Theological Seminary in New York, but he's Irish, born in England, and has since become a Serbian Orthodox priest. His shoulder-length hair and large pectoral cross made quite a stir in the South Florida courtroom. One of the plaintiffs leaned over to me and said, "It's like having Jesus in the courtroom." So for my own part, I testified about U.S. religion, about the fact that without an established religious authority, Americans are very much on their own in determining what religious practices they deem important, so that it is not necessarily appropriate to look to textual or institutional authorities who are ruling on what religious practices are appropriate in a particular person's life. So the city also called two experts in religion. And the first of the city's religion experts testified, so they testified, the two experts for the city were quite a different version of religious studies. This is why you should be deeply suspect of all experts who testify in trials. But anyway, the first of the city's religion experts testified that religion can generally be divided into two types: high religion and low religion. High religion, he said, is textual, institutional, and male. Low religion, he said, is oral, home-based, and female.